My dear friends, RERA is a short form. The full form of RERA is Real Estate Regulation and Development Act 2016. You see, friends, this RERA is a law for the real estate sector in the whole country. Real estate sector, meaning when you buy a house or when you buy an office or when you buy a showroom or you buy a shop or you buy some kind of real estate property. RERA is a central law. It was passed by the Parliament. It applies to the whole of India. Before RERA, there were some problems affecting the real estate sector, especially the residential and commercial property. These problems, they are listed in the Statement of Objects and Reasons in the Act. The sector was largely unregulated. There was no professionalism. There was no standardization of law. Consumers were not protected. There was no transparency in delivering the property, and no transparency in the money collected from the purchaser, and litigation was slow. Therefore, it was decided to put some obligations upon the people involved. Who are the people involved? On whom is the obligation put? RERA puts the obligation, and RERA affects the builder, called the promoter, the estate agent, called the broker, and the allottee, the person who purchases the property from the builder. So these are the people involved. RERA does not involve rental property. So if you are living on rent, you cannot go to RERA against your landlord. RERA is not for rental property. Only when you are purchasing the property, RERA will apply. Now, when RERA came, when this act was passed, the government gazette prescribed the date of 1st May 2016 for half of the provisions of the act, and at the same time, states were told that make your own RERA authorities within 1 year, before 1st May 2017. And Gazette said that from 1st May 2017, all remaining provisions of RERA will come into force. But hardly any state governments complied by this deadline. It was only Maharashtra and a handful of other states which brought this RERA authority on time. In Maharashtra, the Maharashtra Real Estate Regulatory Authority was, I think, the first one to be fully operational from the prescribed date of 1st May 2017. 1st May is also the state holiday of Maharashtra Divas, Maharashtra Day. So the state government of Maharashtra was very motivated to bring these things on time. And on time, the MahaRERA website started functioning. So website was launched and registration of the projects began. Promoters began registering their projects on the MahaRERA website. And as of today, all the RERA authorities are operating, except one or two. Now, my friends, I can humorously say that just like any new law, even RERA's constitutional validity was challenged when it came out. Many people filed writ petitions across the country challenging the constitutional validity of RERA. And then it was decided by the Supreme Court that all these constitutional validity petitions should be transferred to the Bombay High Court. The Supreme Court gave the Bombay High Court a 2-month time limit to finish hearing the matter. And the Chief Justice of the Bombay High Court was told by the Supreme Court that please form a bench to hear all these matters. So all across the country, matters which were there for constitutional validity of RERA, it was transferred to the Bombay High Court, and a bench was made in the Bombay High Court which decided this matter within 2 months. In September 2017, the arguments started, and arguments ended in November 2017. Judgment was reserved in November 2017, and the 330-page judgment was pronounced on 6th December 2017. Now, in short, the content of this judgment is very simple. The judgment says that RERA is a good thing for the customers, and all the provisions of RERA were held to be constitutional and retroactive. Not retrospective, retroactive. So what does retroactive mean? It means that whatever is finished off in the past, that that is not included in RERA. So that is why it is not retrospective. Retroactive means the project which was started before RERA is not yet complete when RERA came. So RERA will become applicable to this ongoing project. That is why it is retroactive. Your project, you have said, will be completed in the future, in the year 2022. So that is why RERA will apply to you. And on the other hand, projects which are finished, meaning projects whose completion certificate has been granted before RERA, RERA will not apply to this completed project. Broadly speaking, when home buyers have grievances against the promoter, there are three options available. Number one, there is IBC. Number two, there is consumer. And number three, there is today's topic, RERA. The allottee can choose any one from the three remedies available. Now, allottee, he cannot do one kind of mischief. He cannot get one refund order from consumer and another refund order from RERA. If this is allowed, that means he will get double of what he has paid. If he has paid 10 lakhs and if he is allowed to get 10 lakhs refund from consumer and another 10 lakhs refund from RERA, then that is cheating. He has received 20 lakhs against this 10 lakhs that he has paid. No, this is not allowed. For each cause of action, you can pursue it only under one code. This is called the doctrine of election. The litigant elects his one option from multiple options. So who are the basic stakeholders in RERA? And who are the basic stakeholders in this real estate field? First, there is the customer called the allottee. Then there is the builder who constructs the building called the promoter. Customer and builder, they come in contact with each other through a broker called real estate agent or estate agent in short. And the agent has to be registered with RERA before he acts as a broker. Then come the government authorities. The Real Estate Regulatory Authority, also called the RERA authority, is the godfather of the real estate sector in the state. He is called the, so basically when we use the word RERA, the RERA word is used to refer to the law also, the act also, and it is used to refer to this authority also. So RERA Act is the law and RERA Court or RERA Authority is this Real Estate Regulatory Authority. Then there is his colleague called Adjudicating Officer. In short, it is also called AO. RERA is actually superior to this AO authority, but I call them colleagues because both RERA and AO orders, when they have to be challenged, they go to the Appellate Tribunal. So there are RERA authority, there is the AO adjudicating officer, and both these people ka orders, when it is challenged, it goes to the Appellate authority, Appellate Tribunal. And Appellate Tribunal orders are challenged before the High Court of the state. Now the customer, he buys a house or an office premises or a bungalow or a plot. Usually the allottee comes across some kind of advertisement, newspaper, or it is advertisement on a billboard or radio or internet or brochure which is displayed by the estate agent or brochure which is displayed by the promoter at the sales office. So advertisement is defined under RERA, and usually they have brochure or some kind of advertisement, and it is a brochure or a poster or on whatever document, they will describe various good things about the project. They will say it is affordable, it is luxurious, it is spacious, you will get amenities like swimming pool or clubhouse or gym, or it is at some fancy location. All these are advertisements by which the promoter attracts the allottees. The allottees either buy an apartment or a plot. So that is the premises that they are purchasing. The premises is itself a building. If it is a plot, it is a standalone building. If it is a plot or a bungalow, so that is the premises they are purchasing, or allottees purchase an apartment. So the plot or the bungalow is itself a standalone building, or the apartment is located, situated in a building. So the building and all amenities, all facilities, and the four corners of the project is called the real estate project. The four walls of the building, including everything. And this real estate project, the promoter has to register with RERA on RERA website. The promoter begins first, the project begins first when the promoter obtains something called a commencement certificate, also called CC in short. This commencement certificate is obtained by the promoter from the competent authority, which is usually the municipality. Then the promoter constructs the project, and when it is fit to be habitable, when it is fit to be lived in, the competent authority will issue the occupation certificate called OC. OC received means allottee can move into the house. And then completion certificate, also called BCC, building completion certificate, means that the promoter has finished everything related to the project. Finished the construction, finished the maintenance, finished the paperwork, and now promoter has to exit the project. Tata, bye-bye, the builder's job is over. Now the allottees are living there in a housing society. So all of these things, he has to do the construction according to the sanctioned plan, which he gets sanctioned from the competent authority. And he has to disclose this sanctioned plan on the RERA website. Promoter is not allowed to construct anything different from the sanctioned plan. And many times amenities are not there in the sanctioned plan, or many times area is less compared to the sanctioned plan. So you see, whatever is the advertisement and whatever is the sanctioned plan, actually delivery and possession of those things has to be given. So if they are saying you will get amenities, then amenities which he says in the advertisement, those amenities have to appear in the sanctioned plan. Many times they give you amenities, but it is not there on the sanctioned plan. And another example of what is the thing of the sanctioned plan, your flats, the area, the plan of the flat, you have to get a flat which is according to the sanctioned plan. You cannot get a flat which is different from the sanctioned plan. So the next definition is carpet area. The flat that you are purchasing, he has to give you the clear carpet area calculation. Before RERA, it was rampant and blatant that your carpet area is actually lesser than what he is telling you. The carpet area you get is usually 0.8x or 0.6x of the total area that they say they will give you. The promoter says your flat is of 1,000 square feet, but actual carpet area, when you measure it and when you see the sanction plans, it used to be 600 square feet or 800 square feet. So that other deficit is not actually a part of your flat, but it is part of some common area, like balcony, which is not sanctioned as a balcony. It is just a slab of your building over which the builder has put cement and claimed it. Or your bathroom or your walk-in wardrobe is actually the duct area, the drainage pipe area, which in the old days used to be on the outside of the wall, outside facing, because if anything in the pipes goes wrong, then it is supposed to be repaired. But builder has not told you this, that this is actually common area. Builder told you that you make a walk-in wardrobe here, it is very spacious. You thought this was your area, you thought this was the area of your flat, but it is actually a dry space on the sanction plan, or it is some other kind of common area on the sanction plan, and it is not part of your carpet area. So carpet area definition is there. And the flat that you purchase, all these area details, project details, A to Z details promoter has to put into something called an agreement for sale or sale agreement, which has all the terms and conditions, and necessary formalities like stamp duty and registrations have to be done along with the sale agreement to complete the procedure of law. Now, what RERA Act says? RERA Act says that this law, this RERA Act, is the godfather law of selling inventory in a real estate project in the state. In other words, whatever RERA Act speaks of, no other law is allowed to legislate. Thanks to West Bengal, I do not have to be hypothetical and I can give you an actual example that happened. RERA Act says that this sale of apartment, making payment of time, etc. topics, whatever RERA Act talks of, no other law can be made on these topics on which RERA has legislated. Now, interestingly, West Bengal legislated its own West Bengal RERA, West Bengal Housing and Regulator Act. Under that, it constituted its own West Bengal Real Estate Regulatory Authority, which was completely different from the central RERA and RERA provisions. West Bengal said that this RERA law will be applicable to us, not the central RERA. This went to the Supreme Court and the whole West Bengal RERA Act was held unconstitutional by the Supreme Court, citing this section 89 and other constitutional provisions. The Supreme Court said that you cannot make another law on what RERA talks about. However, RERA Act in section 88 says that other laws can also apply to RERA, other laws which are not inconsistent and not in derogation. So what does this mean? It means that whatever is inconsistent with RERA, that is unconstitutional. West Bengal Real Estate Act was inconsistent with the provisions of RERA. Central RERA gave Real Estate Regulatory Authority and even West Bengal made its own Real Estate Regulatory Authority. So that was inconsistent. West Bengal was inconsistent with Central RERA. But other laws which are actually consistent will apply. For example, Contract Act, Transfer of Property Act. When we do agreement for sale, I said that necessary formalities like stamp duty registration. So Stamp Act, 1908 Registration Act, all of these apply. All of these are additional laws which operate in addition to and not in derogation of RERA. So that was about additional laws and RERA. RERA Act also says in section 79 about courts, how other laws are not allowed on RERA, just like that other courts are not allowed to do on RERA. Section 79 says that if city civil court or district court wants to send to you using some section 30, 40, 50, 60 of RERA, then that is not allowed. Why? Because only the RERA court, the RERA authority can send summons under the provisions of RERA Act. Other courts are not allowed to interfere in RERA related matters. This is called ouster of jurisdiction. There is ouster of jurisdiction of civil courts. No case is allowed to be filed and no injunction is allowed to be granted by the other courts under RERA provision. Now coming to the godfather authority, the RERA authority. There is not a central RERA authority. RERA Act is a central act, but every state has to make its own RERA authority. Maharashtra has MahaRERA, Gujarat has GujRERA, and etc. So every state has its own RERA authority to govern the matters in its own state. Everything which the promoter and agent have to do, they have to do with this RERA authority. Register the project on the website, RERA. Make disclosures with RERA. Now another example, promoters have to disclose their partners, directors details on the RERA website. But if this changes, one partner leaves and some new partner or director comes, so the constitution of that firm or the company has changed. Who do they coordinate with? With RERA. Another example, this promoter cannot finish the project because he is into losses. So he decides to sell this project to a new promoter. So there is a new incoming promoter. So these two promoters, to modify everything and do the necessary formalities, they have to coordinate with the allottees and with whom? With RERA. So RERA is the godfather of the construction and the sale of real estate in the state. But if you think that this RERA Act is 100% of the law, you are wrong. RERA Act is only 30% of the law. And I'm not even talking about those other laws like contract and transfer of property. State government and state RERA authority will fill in the 70% of the RERA law with the respective state rules, regulations, circulars, etc. Whatever fill in the blanks are required in the RERA law, the state government and state RERA will do fill in the blank, because RERA is the regulator of this field in its state. Real Estate Regulation and Development Act, Real Estate Regulatory Authority. So now what does this regulator mean? It means that RERA authority will regulate the law instead of parliament or instead of state legislature or instead of state government. So instead of government of Maharashtra, notification for the field, now RERA circular and notification will govern the field. What does this mean? It means that when the coronavirus came in March 2020, there were long lockdowns. But in Maharashtra, projects have been registered from 2017 onwards, and 6 months lockdown means at the very least 6 months delay in completion. So RERA, being a regulator, extended the dates for the project completion. If RERA was not there, then state government or state ministry or the undersecretary or assistant secretary, chief secretary, etc. of the state, these people would have to publish it in the official gazette, and that would also have to be seen whether it would be valid. And state has a lot of work and a lot of burden. So this concept of regulator is called the doctrine of separation of powers mixed with the concept of delegated legislation. The regulator legislates because power is given, power is delegated to him by the statute under so and so section. So COVID example is an example of a regulator. What other types of circulars RERA puts out? The RERA authority connects the state land laws with the central RERA Act. State government will come out with rules, circulars, etc. to connect occupation certificate, completion certificate, sanction plan, etc. from RERA definitions with the your state land laws, which is the Municipality Act usually, so and so Corporation Act. Also, not just for the state land laws, RERA will fill in the blanks for even the RERA procedures which are mentioned. So which all documents promoter has to upload, it will be given in the rules and circulars. Which all formalities have to be carried out by the promoter and how they have to be carried out. These delegated legislation will do fill in the blanks. How to operate the RERA bank account, how to carry out the withdrawal, RERA will clarify. Another example of this circulars and procedure, when completion date of the project has come, but promoter has not completed the work, then project might be headed for a lapse. The registration will be lapsed, which means that promoter will no longer be allowed to interfere in the construction of the project, and RERA will take over the project. This is usually a last case scenario. So the specifics of all this procedure of the lapse of registration and takeover of project, these fill in the blanks RERA authority and state government will do by circulars or by rules and regulations. So RERA's first function is being a regulator, and RERA's second function is being a court, a judicial function. So when promoter or allottee have a grievance against one another, they file a case at the RERA court. The next important authority is the Adjudicating Officer or the AO. The job of the Adjudicating Officer is solely to give compensation in the complaints. I will come to the procedure in a little bit, but the factors which he has to take into account for granting compensation are mentioned in section 72. how much is the wrongful gain to the wrong party, how much is the loss caused to the correct party, how many times is the offense repeated, what is the frequency, that suppose promoter has done this with all the allottees in the project, or the same promoter is doing this kind of wrongdoing with many other projects that he is constructing. So frequency and any other factors which may be necessary. Then there is the appellate tribunal. The RERA and AO orders can be challenged to the tribunal, and this appeal is called the first appeal. Now, one interesting fact about appellate tribunal, the RERA Act had one qualification which was a non-judicial qualification for a judicial member post. The RERA constitutional validity judgment only held this thing as negative and ultra vires, that this additional secretary qualification for judicial member post is ultra vires, and other than this, all other provisions of the act are strongly upheld. So now coming to the project. Before the promoter can make a sale in the project, he has to register the project on the RERA website. Every state RERA has its own website. When he registers the project, everything about the project has to be disclosed. The list of the things that are to be disclosed are given in the sections 3 to 8, and additional things, additional disclosures are given in the rules and circulars. For example, date of completion of the project, who are the director partners of the firm or the company, how much litigation is ongoing, what is the project boundary which will become the property of the society, what are the drafts of the agreement of sale that will be executed. All details you will find on the RERA website for the project. The project is subject to sanction plans and advertisement. Promoter cannot modify the sanction plans and the advertisement without the consent of the allottees and of the RERA. Then promoter has to give possession to the allottees, and he has to form the legal entity like a society, a housing society, or a condominium. Refund is there in cases where allottee wants to exit the project for fault of the promoter. So allottee will ask for interest, he will ask for refund with an interest. And in the opposite example, the promoter cancels the allotment because allottee has not paid from time to time. So promoter will deduct damages and he will issue the refund. So that is the refund. When anyone makes an offense, obviously there will be litigation and obviously parties will compensate each other. But before we talk about that, you should also know that in addition to those compensation, refund, etc. things, the person might have to pay a penalty to RERA also. These penalties go up to 5 to 10% of the cost of the project. So this cost of the project will already be certified by a chartered accountant of the promoter. So if that total cost of the project is say 25 crores for constructing a 7-floor building with about 14 to 28 flats, 2 flats or 4 flats per floor, then the penalty 5-10% is up to 1.12 or up to 2.5 crores, which is not a small amount, even in a small project like this. Projects can go up to hundreds of flats. In Mumbai, there are many projects with 200, 300, 400 and even 500 flats. 5 big towers are made. So you can imagine the 5 to 10% quantum. Now, how the parties become liable? Allottees become liable if they do not comply with the orders of the RERA court, the AO and the tribunal. Then estate agent becomes liable if he acts as an agent without getting registered with RERA. So even agent registration is there, or this agent does some kind of unfair trade practice, or agent does not comply with the order. Penalty will be levied. And promoter becomes liable in many ways. He has not made proper disclosures, penalty will be levied, or project is needed to be registered, but he has not registered the project, which means that he has sold flats and is advertising without doing the registration with RERA. I have myself argued many of these non-registration complaints. Project was supposed to be registered, but has not been registered and penalty is imposed. Then then penalty is levied if RERA Act provisions are not followed by the promoter. And lastly, if promoter does not comply with the orders, or penalty will be levied. So what is the general process of purchasing a flat or construction of this whole sector? Promoter will obtain the CC, the commencement certificate. Then promoter starts the construction of the building as per the sanctioned plan. Then promoter will register the project with RERA and he will open the RERA bank account in the bank. Then the promoter can do advertisement and he can do sale of his units. He can sell his units, and then allottees come into the picture. Allottees have to make time to time payment to the promoter. Promoters and allottees. Promoter will enter into agreement for sale with each and every allottee. Each allottee, one agreement, or each flat, one agreement for sale. Then promoter completes the construction and hands over possession of the apartment or the plot to the allottee. And in the course of things, the society or the other legal entity will be formed and handover of the property is done to this legal entity. This is called conveyance to the society or legal entity. And conveyance is a very important act. Now, it seems simple enough to carry out all this. But like we saw in the statement of objects and reasons, there were many problems in the industry. And allottees faced many kinds of issues. Number one, possession was delayed. Promoter has said you will get your flat by 1st January 2021. But 2 years have gone, 3 years, 4 years, 5 years have gone. Possession is still not given. Then the promoter changes the flat. Now, when you went to him, when you saw the advertisement or the brochure and you saw the map, the promoters will show a map in the advertisement. They will show the shape of the flat and the area of the flat. But actually, when possession is given to you, that area has changed. Or you are promised that you will get some amenities like swimming pool, clubhouse, or gym, but now those amenities are not being delivered. Then the project is not registered, or the permissions from the competent authorities are not in place. He does not have occupation certificate, but he has given you the flat saying take possession, which is not allowed. So permissions are not in place. Not disclosing encumbrances, that there is ongoing litigation on the land, there is ongoing loan on the land. If he does not disclose all that to you, that is a wrong thing. Then intentionally, he is not forming the legal entity. Around when 51% of the flats are sold, he is supposed to form the legal entity. But 80% of the flats are sold and he is not forming the legal entity. Then he forms very one-sided agreements that if the promoter wants, he can cancel anytime. If the promoter wants, he can change the flat area anytime. If the promoter makes any kind of wrongdoing, promoter will only pay 9% interest as penalty. But if the allottee makes some kind of default or breach, then allottee will be charged 21% penalty. So this is one-sided agreement. Handover is not being done to the society. Advertisements have turned out to be some false or misleading advertisement. Money is collected, but accounts are not being given. Receipts are not being given, and audited accounts are not being given. Then agreement is not entered into, or title is defective. He does not have the title to construct, and someone has now filed a case saying that that builder is not the owner of the land. I am the owner of the land. Builder has usurped my land, and builder is constructing. So that title is not proper, land is not properly acquired, or construction is not done properly by the builder. Then website has to be updated every quarter in the month. So that is not being done. That is an issue that is faced. And construction is defective. He said that this is actually a strong building, but I punched the wall and the wall has a hole now. This has actually happened. So the construction of the building is very bad. It is bad workmanship, bad materials, bad quality. So broadly speaking, these are the issues which are faced by the allottees. So then what is the litigation procedure under RERA? before filing a case, allottees usually ask for a refund with an interest. And if this negotiation does not work out, then the allottees file a case. Or in other types of complaints, the society files a case against the promoter in the RERA court for the statutory obligations of the promoter towards the society, not just towards one or two allottees. Conveyance is not given, construction is not according to plan, etc. Even society can file a case in RERA against the promoter. Now, when RERA was new, there was a lot of confusion about what are the limits and powers of the adjudicating officer, AO. In some states early on, the AO also heard complaints just like the RERA authority. If people wanted compensation, they will file the complaint with AO. And if they do not want compensation, if it is just something like give me refund with interest or you comply with provisions of the act, then they file the complaint with the RERA authority. Over time, the process has become streamlined, and now most states, they do not allow AO to do all kinds of complaints. Now usually the procedure is, they say that you can file AO compensation complaint only after you succeed in a RERA complaint, because otherwise there is multiplicity of proceedings. So now usually most of the states say you file RERA complaint. If you succeed in RERA complaint, you take this RERA order and you file a AO complaint for compensation, because otherwise there is multiplicity of proceedings based on the same facts in the same project. One above wala flat has gone to RERA authority, uske niche wala flat allottee has gone to the AO, and now they have had different outcomes based on the same facts. One person has lost the case and one person has won the case. So to avoid this kind of an inconsistency, the general procedure which almost all states have adopted is that you get a RERA order. If you succeed, then you can take it to the AO for compensation. So all this process is clarified in the rules and regulations and circulars of the respective states. But one general thing Supreme Court has clarified, AO does not have the power of revocation of the project registration. In the same section as lapse of registration, there is also revocation of registration. If RERA wants, it can cancel the promoter's rights in the project because the promoter has done so many unfair things. So those are the grounds for revocation. And this revocation power is only with the RERA, not with the AO. Revocation and lapse means promoter cannot continue construction. RERA will take over the project. And revocation and lapse means that the website RERA project, which promoter himself created ID password, now promoter will not be able to access it. Someone else will hand over the completion. RERA and AO orders can be appealed by the aggrieved party to the tribunal within 60 days of the orders, and subsequently tribunal order can be challenged in the High Court in 60 days. Then depending on whether High Court grants a certificate, you have 60 to 90 days to challenge it in the Supreme Court by way of a special leave petition, challenging the High Court order. And lastly, my dear friends, if you think only allottees face problems, you are wrong. Many times, even promoters face issues. Many times, allottees do not make payments of time. They will go on skipping payments. And if allottee does not make payments, how can the promoter construct if he's not getting the cash? Many times, allottees refuse to take possession because they are disputing some quality of construction, etc. Many times, allottees do some kind of renovation, but that renovation violates the sanction plan, and because of that, the competent authority is not granting the occupation certificate or the completion certificate. So because of allottee's fault, promoter and all the other allottees are getting stuck up. Many times, market scenario is bad. There is not much sale happening or prices are coming down. For example, during the coronavirus, many times someone files a case in the courts or with the corporation or with the competent authority and some kind of stay is granted or stop work notice is granted, which delays the construction until it is set aside. So, for example, 2 months it took to vacate the stay or vacate the stop work notice. And last but not the least, land costs can be very high, especially in Mumbai, where property prices are one of the highest in the world. So, my friends, those were the grievances faced by the promoters. And with that, I have finished explaining to you all the basic provisions of this RERA Act. So, in short, RERA Act is very straightforward. It says that the promoter has to comply with all the RERA obligations. Promoter has to do the construction on time and give the possession on time, and don't do any kind of wrongdoings. In short, that is what the RERA. There is one question. Do we have any direction or clauses for calculating maintenance charges in RERA? No. Maintenance charges, it is purely contractual, and the formula is not given for maintenance charges. Could you highlight the overarching authorities of RERA, BMC and SRA, their powers, limits and jurisdiction? See, BMC or the corporation, the Municipal Corporation of Greater Mumbai is the competent authority with whom builder has to coordinate for permission to construct the project. The certificate is issued by the BMC, certificate is issued by the BMC, and all other modalities of construction are coordinated by the promoter with the BMC. So BMC is the competent authority. However, SRA can also be a competent authority when it is a slum project, when slum is being taken over and redeveloped. So that time the competent authority is not the corporation, it is the SRA. So basically it is upon the promoter to analyze and ascertain that if he is constructing in so and so area, who is the competent authority? Is it the corporation? Is it the SRA? Is it the MMRDA? Is it the MADA? So those people are the competent authorities, and RERA is the regulator with whom promoter has. So RERA is the contact point between the allottee and the promoter, and those other competent authorities, allottees, purchasers, customers are not concerned of promoters relation with corporation or promoters relation with SRA. Allottees are not concerned with promoters relation with competent authority. Promoters are only allottees are only concerned with promoter and RERA. So that is the connection between RERA, BMC and the other competent authority. Next, how effective MAHARERA orders are and what are the consequences of not following the RERA order. So when RERA order is passed, the parties have to comply it, and if they do not comply, there is a mechanism for execution, enforcement of order, which is done with the CPC, the Code of Civil Procedure. The RERA order, usually the RERA order says that so and so party will pay the other party some compensation. So if the other party does not pay the compensation, then the whoever is the winning party, they can send it to execution. And execution means that whatever is the debt, whatever is the money to be paid under the order, that will be paid as an arrears of land revenue under the land revenue code, and the matter will be sent to the district collector. So 1 lakh or 1 crore has to be paid. That will now be reflected in the property tax of the losing party or the land arrears of the losing party, which means that if the losing party does not comply with the order, there will be an attachment of the property and there will be an auction sale. So the party is supposed to pay the money under the order. He has not paid. The winning party has gone in execution. The executing authority, the RERA is itself the executing authority. It will issue a certificate. That certificate will go to the collector, and collector will attach the amount of in that certificate, that much amount, it will come as an arrears of land revenue. So the 1 crore under the judgment, the order will now be reflected in the taxes of the losing party, and if the losing party does not pay that tax to the government, then government will initiate acquisition proceedings for the property. So that is how orders are implemented.
I was just wanted to ask, I had booked a property in 2009.
Okay.
And there's due to delay in construction, in possession also.
Okay.
What are the other remedies other than refund of money?
When allottees have a possession related complaint, there are two options. Allottee will say, number one, I don't want to wait anymore. I want my money back and I don't care about the flat. So that is refund option number one. And number two is we file a case for possession. So the case is that you said possession will be granted on so and so date. In so and so document, possession date is mentioned. That date has come and you please provide me the possession. And if he is not providing possession, you can get compensation.
So the date was mentioned as already gone behind. Actually, into 2009, I had booked and they had promised me to grant possession in 2012. But
verbally
now,
or in writing, sir?
Verbally only.
So that is the wrongdoing that they do. They are supposed to commit a date to you in writing. What I suggest, you send them an email or some kind of letter or legal notice saying, put it from your mouth that you have told me possession date is so and so, and then file a case with RERA. If you do not place possession date on record, where is the property, sir? Is it Maharashtra?
Yes, it's in Kalyan.
So generally what Maharashtra is that if you do not have any possession date, then your submission is not going to be taken by the RERA. The RERA is very reluctant to accept these verbal dates. So what they suggest is that before filing a case, you place it on record, let the promoter deny or accept or whatever, and then you file a case saying you told me it will be possession will be in 2012. Send this email or hire an advocate, send a legal notice saying all this, and then file a case with RERA. Otherwise, RERA will say that no, there is no possession date on record, and RERA might be reluctant to agree.
Yeah, thank you, sir. So they do have a registration with RERA also, and they have extended the.
That's what they will have mentioned a very futuristic date now. In Kalyan, what is the name of the project?
It's Neptune's Swarajya.
I see.
And
so
now the bank is.
I'm very sure that they have extended the date of possession. Even though they told you 2010, if the project is registered, that means they have still not finished construction. And if, sir, I'm sure that they must have registered when RERA came out, right? In 2017, they must have registered.
Yes, sir.
So I'm sure extend 2021-2022 का date दिया रहेगा. Have you seen the RERA website?
I've seen it, but it is just extension because because of pandemic they are saying right now.
Yes. It was extended by six months because of pandemic. But even before pandemic, he must have extended to very much in the future. Well, even before pandemic, he must have mentioned 2019-2021 possession date, I'm sure.
And now currently the bank is waiting for the final disbursement.
Okay. What's the effect of Limitation Act provisions? See, RERA intentionally has not kept any limitation, and that is, so RERA Act does not have any limitation, and the Limitation Act will apply, which usually 3 years is the date of, is a limitation period. But RERA has extended that also. Cases beyond 3 years also have been granted the orders. Now, what is the general principle consumer courts and RERA follow? Like in Dinesh sir's case, possession was to be granted on X date, say 2012. Now, limitation, there are two factors which go into limitation. Number one, promoter has not said anything about the possession, or in other words, promoter has not cancelled, which means that even though Dinesh sir was supposed to get in 2012, till date, promoter has not said no. Till date, promoter has not cancelled his allotment. So if allotment is not cancelled, even if 100 years flat is not delivered, you can file a case after 100 years because that is a continuous cause of action. Your cause of action is continuous and recurring with each and every day. So even 5 years later, even today he has not delivered. 5 years and 1 day later, even today he has not delivered. So limitation will not apply. And in the other scenario, 2012 he was supposed to get possession. finally say he got in 2015. So there he has received possession, and from the date of receipt of possession, he has 3 years to file the complaint. So in scenario number 1, possession is not received. That is why limitation will not be a problem. Scenario number 2, possession is received, delayed possession is received, and 3 years will apply from the delayed possession date. And in a third scenario, because of some misunderstanding or a non-agreement between the parties, promoter says your allotment is cancelled. Allottee is not paying on time, or some obligations are not being complied with. So limitation 3 years will also start in scenario number 3 when allotment is cancelled. So from that date, 3 years time limit is there. So scenario number 1, flat is not cancelled, unlimited limitation. Scenario number 2, possession is granted. So from 3 years from date of possession. And scenario number 3, allotment is cancelled and 3 years from the date of cancellation. So that is limitation. But the RERA authorities have also bypassed limitation, saying that this is a very welfare law. So don't get too much into technicality. How long does it take for execution of order if promoter are not cooperating and not following? See, actually, I am very sad to say that RERA execution was quick in the past, then it slowed down for 1 or 2 years, and now finally they have constituted an authority for carrying out execution, and there are hopes that now execution will speed up. But unfortunately, it's still a little slow in Maharashtra. So people have to obtain high court orders directing the RERA authorities to carry out execution. That is a slightly sad state of affairs, but that is how it is. Execution is a little slow in Maharashtra. If project is added in the blacklist by RERA, what are options available to the builder to resume his project? See, blacklist is another thing. The bigger thing is revocation of registration. Blacklist means blacklist comes later. First, promoter has done some kind of wrongdoing because of which he is blacklisted. So what is the preceding event? Is the registration cancelled or only compensation, etc., or some remark is passed? Normally what this RERA Act speaks of is that if he is revoked, if the registration is revoked, or if the promoter is disassociated from the project, only then there will be a blacklist and no other scenario. So what that means is that once he is blacklisted or that once registration is revoked, that promoter cannot deal with the project again. So that is the answer to that. Promoter cannot come back in the picture for the project if he is disqualified or registration is cancelled or if he is blacklisted.
Good afternoon. I have 3 questions. This is Mandar speaking. Basically, when we see the RERA certificate regarding one project, I could see the 40-story building which has been approved by RERA, but the CC which is granted for only 29 floors. So how come there's a discrepancy? And how
that happens. They get CC in bits and pieces, CC up to so floor, and then they go on obtaining upper floors. That is
okay. So there is no issue in that.
There is no issue. No, see, this is also broadly speaking. Other factors have to be looked into. Whether he is constructing without CC, whether he has sold the flats without CC. Other factors need to be looked into. It doesn't invalidate the construction. It just means that allottees have a stronger ground for complaint.
Okay. And the same project, the thing is that the official developer is different, but the project has been developed under different brand name. So in case of any discrepancy or in case of any legal recourse, I do not have a recourse against that person who's selling.
You have against both. They are both promoters.
No. Promoter is only one. Promoter or developer is one. And one is project developer. Project developer as in project manager.
You read the definition of promoter.
Okay.
Even the other part, that other promoter, both these people are responsible to the allottees. And agreement, their contract, these people have to put on the RERA website.
Officially, they have mentioned themselves as project managers.
Still.
Okay.
Their contract they have to upload on the RERA website. See, this is also a very normal thing. One party constructs, other party handles the maintenance or sales or marketing, or other party owns the land. All these people are promoters within the definition of promoter.
Okay.
You're practicing in Mumbai, Maharashtra?
Yes, Mumbai, Maharashtra.
Yeah, you read the circulars. Even circulars have clarified this, the co-promoters and all those things.
Okay. And so last question. In most of the agreements, most of the agreements are unilateral in nature. Basically, builder says that you have to sign it and we have to sign it. Does RERA talks about it?
Yes. One-sided agreements are not allowed under RERA. You can challenge it.
No, we don't have any recourse. We just have to sign it. So we can't put our clauses in that agreement. So,
no, you sign it. You have no option. I agree. They just call you for registration or they themselves send you the letter. And immediately after that, you send a letter saying so and so is not allowed. Immediately you file a case at RERA that so and so is not allowed. This is where I personally prefer the Consumer Protection Act, where you can get it declared from the State Commission and National Commission that so and so terms are null and void.
Okay.
Yeah.
Thank you so much.
Next question is here: what parts of central and state laws are applicable? All parts of state laws are applicable. Why will anything be inapplicable? What are the obligations of CHS or tenants in a redevelopment? See, Sujay, this is a complicated topic, and the CHS and redevelopment rules will differ from state to state. Next, will there be interest on interest not paid? That is arrears on interest. No, there will not be interest on interest. There will be interest on arrears. Your allottee is supposed to make payment, has not made payment, and builder has levied the interest, and that will continue accruing until compliance. If I approach promoter to purchase a plot, and if they are selling on super built area or violating any RERA rule, can we complain? Yes, that is what. They are not allowed to sell on super built up. They are only allowed to sell on carpet area. In redevelopment, RERA applies for old flat owner. See, redevelopment matter, why it is a little complicated or whatever, there are two angles involved. Number one, the entity, even the society becomes a promoter. That is one, not exactly gray area, but that is one complicated issue. So, RERA applies in redevelopment, but more importantly, RERA will apply only when new flats are constructed in a redevelopment. So, if there are 10 existing flats and redevelopment, only 10 are remaining. No extra flats are being sold, so that redevelopment project does not have to be registered. But that is only for Maharashtra. The rules may be different in other states. So that is the logic. Redevelopment is a slightly complicated topic, and I would prefer not getting into the generality of it.
Yes. I booked the flat somewhere in 2017.
Okay.
And that possession was somewhere in December 2019.
Okay.
And later on, he has changed. And of course, as you are aware, the agreement is unilateral.
Yes.
Like interest, if I delayed it 18%, if they delayed 9%, and then later on this is registered in RERA, and then the possession is then instead of 19, which is agreed in agreement, is now in December 2021. So
you can file a case.
I already filed the case in RERA, and I filed the case for compensation because I have made almost 100% payment. That was and waiting for these things to happen. And I just wanted to have one more question.
Yeah.
They have insisted to pay. This is 2 BHK in a tower of 36 floors.
Yeah.
They have insisted to pay for parking separately. But as per this, if it is 2 BHK, I think parking should be part of this one. So
under RERA, Maharera, is it Maharashtra property, sir?
Yeah, it is in Maharashtra. It is in Bombay.
Closed parking is allowed to be sold, and there are circulars how to categorize closed parking. But if it is not closed parking, he is not allowed to sell the open parking.
Okay.
Yeah.
So he's allowed to sell the closed parking, right?
Yes, he's allowed to sell the closed parking. But sir, what I suggest that you ask him whether this is going to come in the open parking or closed parking. You ask him whether he is going to give you a receipt for the parking payment. If they are selling parking in black, they will not issue you a receipt. And that is how you will come to know that he is not supposed to charge for that money. And open parking goes to the society. Builder is not allowed to sell the open parking. When society is formed, let me tell you one thing, sir. Even when builders charge for open parking, even before RERA, So society is formed, that parking letter becomes null and void. As soon as society is formed, that open parking becomes the property of the society. Society, as per bylaws, has to allot the parking. So open parking, common, which is in the common areas, that he is not allowed to sell even after RERA. And if you discuss with him and you can take it up with me afterwards. And if it is closed parking, only then he is allowed to sell.
Yeah, and one more question. So when this is some compensation will be this one, it will be based on the interest charged by promoter, or what is
No,
on
I
the
showed you
interest?
in that section 73, the factors will be taken. How
Okay.
wrong thing he is doing, how much loss is cost to you, how much wrong is cost to him. So if he is delaying possession, wrongful gain cost to you is that much amount, and wrongful loss cost to you is that much amount. Wrongful gain gained by him is that he is enjoying for 2 years, enjoying the interest. So all these factors will be taken into account by the adjudicating officer.
Okay. Okay. Thank you.
Whatever your grievances are, that sometimes you are going on making loan installments even beyond the possession date. In other times, a builder who is supposed to pay the EMI, he does not pay, and additional amounts are charged. Sometimes because of builder's fault, your CIBIL score gets affected. All these points you can raise in the compensation complaint. Wherever you feel you deserve compensation, add it as a ground.
Okay. Okay.
Yes, sir. Someone is asking what is the difference of duties of powers between AO and RERA authority. See, AO is only for compensation, and RERA will deal with all other types also, the registration of the project and revocation of the project. If promoter has changed anything on the RERA website, it will contact the RERA authority. RERA authority will issue circulars. So that is the basic difference. RERA is the main boss and AO is for compensation.
Hello.
Yes.
In a particular project in Mumbai, the payment is done, the building almost completion certificate obtained, people started staying. The builder is not leaving the premises and is not allowing or handing over the property for society formation.
He is not forming society?
Yeah, we are yet to form. I am one of the buyer in that. Now we are unable to, because he's not giving, and neither he's leaving that, he's not maintaining the property well, saying that he has maybe out of 500 flats, maybe 10 or 8 are pending for sale. Remaining all sold, almost over 50% are occupied already.
Yeah.
So what is the recourse available for us to
You can
form
file
the society?
RERA complaint or consumer court complaint for society formation and conveyance.
Okay, for formation of society or for asking him to vacate?
If he has flats in the building, he need not vacate.
Okay.
Does he have flats in the building, sir? Any idea?
He is telling he has very single digit, some maybe 5,
so
8.
Basically, he wants to hold on to some flats, and society registration, when the papers of society registration proposal goes to the deputy registrar, at that time to know that he is still holding on to so and so inventory. So it's a case at either consumer court or at RERA for the society formation and conveyance and other relevant prayers.
Okay. So we also, among the buyers, we formed kind of a informal discussion, and we felt like there is some option of going for a non-cooperation way of forming the society.
So non-cooperation, it is never advisable, because formation of society, all the details have to be entered. What is the area of the society? What is the FSI used? All the purchaser details. So these all are, and what are the books of accounts? So these all are usually best done by the promoter instead of going by non-cooperation, because if you go by non-cooperation, you will make some mistake, and you should never take this on yourself, all these registration matters. It is only under exceptional circumstances that we advise. So instead of you going, you file a case saying that you please register the society according to law.
Okay, and that can be under RERA or consumer protection?
Both, sir. You, for whatever case you can file in RERA, you can also file in consumer court. As advocates, we analyze that for this requirement of the client, where do we file consumer or in RERA?
Okay, but we can choose any one.
Correct.
As you said earlier,
Correct.
And the preferred route would be between consumer and RERA?
In this matter, I think in this matter, see, basically, sir, superficially speaking, RERA will give you quicker order to an extent, but consumer will give you heavier compensation.
Okay.
So it is a judgment call. And quite unfortunately, even the RERA authority is taking a bit of time now. There are delays. And unfortunately, the speedy justice that was once the promise of RERA, that is slowing down slowly and slowly. And now RERA is also taking the same time as consumer. So we are of this thing that most of the RERA matters consider filing in consumer, because it is taking the same amount of time, and consumer courts usually grant stronger orders.
Yes, I think, my view also, initially RERA was faster. Now with the more number of cases, particularly in Maharashtra or, some...
unfortunately,
yes.
it is not even the RERA's fault. The law has made it that just 2-3 people, this RERA authority, 2-3 members, 1-2 AO for the whole of Maharashtra. So the law is to blame for that. There's more officers. We need more officers. These 3-4 people for the whole of state is practically impossible.
Yeah. And I think one important aspect, you said the open area, not authorized by the builder to sell.
Yes,
you can only sell covered. By here, actually, it's mixed. Some covered are there, some open. So typically on the, passage or somewhere open area, those also he has sold actually. Open at a lesser price, covered at a higher price. So those, I think, those open sale you are telling can be null and void once society come.
No. That I was talking about open parking.
Okay.
Not your open balcony or something.
Okay. No, in the open parking is allowed, you are telling.
Open parking, he is not allowed to sell. Open parking has to come to society.
Okay, exactly. But builder already sold open parking also.
So that's what. All those people, they will go to court, sir. Trust me. This all is very normal. They will go to court against society or against builder. If they are on society's side, if they are aware of the law, they will file a case against builder. Otherwise, if they want their parking selfishly, I don't want to use the word, but for lack of a better word, if they want to be selfish about their parking, or if they are hand in glove, builder ke saath mile hue hai, then they will file the case against society.
Okay. And the last thing, sir, if you allow that, while doing the due diligence of the property and bank process we found that on the land, there are certain, claim, some dispute. But even bankers has put that as a point, and then we have to give an indemnity for that. They said that we will pass the loan. It looks like because after the bank disputed date, the RERA approval is there and the building completion certificate already obtained. So,
after the disputed date as in?
Sorry?
After the disputed date as in?
I mean, there is a land dispute on the land. Some people are claiming that is in, let's say, 2015. But in 2017, RERA registration done, 2019 building completion taken, 20 onwards possession given. So do you see any, as a buyer, you always have in the back of my mind that in the land there are some dispute. Can it come in future and can have any impact?
Of course. Let me tell you, sir, there have been cases where the builder does not have the authority to construct now what happens is they sometimes take the property on lease to construct, or they take some kind of power of attorney to construct, and the parties, the deal breaks. They file a case for cancellation of the deed or cancellation of the power of attorney, but builder still goes on constructing. So basically what these scenarios are, he has not disclosed encumbrance to you. Has he told you in the past that there is a court case going on?
No.
So he has hidden the encumbrance from you. So you are entitled to the case.
But since bank loan was approved, I was thinking that is a filtration check or protection for me.
It is a filtration check, but as a precaution, not as a statutory thing.
Okay. And we have given that indemnity. That's why we are talking that
so you are not even supposed to give that.
Yeah, but to process the loan, they said you have to give an indemnity if at all something goes.
Exactly. So builder, because the builder has not disclosed his encumbrance, you are made to.
Yeah. Okay. Thank you so much.
Considering the case, sir, it seems like a good case in consumer because many sections seem to be violated. You seem to you can make many good prayers in consumer, it seems.
Yeah. Thank you so much.
Someone has asked in which court we suit for compensation matters of RERA. AO, you file it with Adjudicating Officer.